Perspective. I am Jawati Hamid. The political temperature, especially in Punjab, has risen after the election of Chief Minister Punjab. A couple of days before, Hamza Shehbaz grabbed 179 votes and he stood out victorious. And that happened after the Deputy Speaker, Dost Mohammad Mazari, rejected 10 votes of PMLQ, which was in alliance with Pakistan Tehreek-e-Insaf. Hence, the Pakistan Tehreek-e-Insaf and PMLQ joint candidate Parvez Elahi went into the Supreme Court challenging the ruling of the Deputy Speaker Dost Mohammad Mazari, and the hearing of this particular petition is underway, which will be resuming tomorrow with Chief Justice Omar Ata Bandial in the chair of this particular hearing of the petition. And now, regarding this particular thing, the ruling coalition has requested and decided to file a plea in the Supreme Court in order to form a full court for the hearing of this petition. And their leaders have been saying that the ruling by the Deputy Speaker was in line with the Constitution, and not only in line with the Constitution of Pakistan, but also an earlier verdict by the Supreme Court of Pakistan on 17th, in which it interpreted the Article 63A of the Constitution. Let's bring in our panelists in the show. I am today joined by Mr. Muhammad Jalaluddin Advocate. He's advisor to JUIF. He's joining us in the studio. Thank you very much for being here at Perspective. And I'm also being joined by Mr. Asif Mahmood, who is a political analyst. He's also joining us in the studio. And we are also being joined by Mr. Balagh Sher Khosa, advocate, Supreme Court and legal expert. He's joining us on Skype. Let's begin the discussion with you, Mr. Jalaluddin. Why is the ruling coalition requesting the Apex Court to form a full court regarding this hearing of the petition?
The present bench has the people of Pakistan have lost confidence in the present bench, because this bench has become a perpetual bench dealing with the constitutional issues. In our Supreme Court, we have 17 judges, and it is not fair that each and every critical constitutional issue is to be decided by only 3 judges. So the opposition has demanded that, being a critical constitutional issue which will affect badly or rightly the future of our democracy, so in the context of justice, we have demanded that full court should be constituted, so that all the judges should sit together and find out a constitutional way out of the present crisis. Though the situation have become to the extent that even still the case is not heard, but people are just gossiping that Parvez Elahi has become the chief minister. So if the people with lost confidence in the judiciary, I, being as a lawyer, I am of the opinion that this is also the duty of judiciary to repose the confidence and maintain the confidence of the people on it.
But there is a particular process through which these judges are appointed, and it's an elaborate and comprehensive procedure, of course. And this particular bench is headed by Chief Justice of Pakistan himself. So don't you think it's the matter of judicial discretion solely whether the Supreme Court Chief Justice considers and accepts the demand that has been made by the ruling coalition?
The appointment of judges is a separate issue, which is also very much objectionable. The Pakistan Bar Council, Supreme Court Bar Association, all High Court Bar Association has questioned the appointment of the judges. So appointment is another question, but the constitution of benches in another question. Our senior most judge Qazi Faiz Isa has reservations on the constitution of these benches.
Well, let's talk about, Mr. Jalaluddin, let's talk about the judicial discretion regarding this particular petition that has been filed and that's being heard by the Chief Justice in the chair. Now, when we talk about the request of the ruling coalition to form a full court, don't you think it's the matter of judicial discretion whether the Chief Justice of Pakistan wants to entertain it or not?
So there are precedents that on such issues full court has been constituted. Like in Qazi Faiz Isa case, the full court was constituted because he was of the opinion, and the lawyers, the Bar Council, the Supreme Court Bar Association, they were of the opinion that there are some judges who, according to Qazi Faiz Isa, are biased. So when the question of bias comes, our superior court, this is our precedent, that judges, without asking by the party, themselves get out of the bench. That if the certain litigants or the parties, if they have not confidence on the court, on the judges, so the judges themselves get out of that bench.
Right,
and especially what is objectionable, that no, this bench has become a permanent bench headed by Chief Justice. On each and every constitutional issue, we have 17 judges. Why not? The precedent is that whenever Chief Justice, the Honorable Chief Justice constitutes a bench, it is constituted on the basis of seniority. So the Chief Justice, the other member, senior most judge, the other third one, the other fourth one, not pick and choose to pick
one.
Let's
bring in Mr. Asim Mahmood. So the logic behind the demand by the ruling coalition to form a full court into this petition, what's your take on that?
Well, I say this is very sound logic, and I second it. There are many grounds, because that's why I'm saying that I second it. We were actually, I dare say, we were expecting that this election will actually fade and the ball of confusion will be over. But unfortunately, the story is turned absolutely opposite, and now we are witnessing another crisis. Actually, these are the politicians, I'm sorry to say, these are actually the politicians, our legislature, that has failed to legislate crucial issues, and everything is left over on discretion of the court. As far as the formation of the bench is concerned, yes, my friend has raised very crunch question. What is the criteria? Is there any rules? Is there any procedure? Is there any legislation by our parliament that this is the way to constitute a bench? No, nothing, sir. Our constitution is silent over it. Our legislatures have never ever pondered over this issue. So everything is dependent upon the discretion of the Honorable Chief Justice of Pakistan. Now the question is that when you are deciding a case,
that must be because of the confidence, the trust the nation and the institution pose at the highest seat of justice.
Of course, we have high level of confidence in our institutions. We must respect them, and whatever the decisions come, we should even honor and respect that decision. But I must say that when the court is going to decide a constitutional matter, I mean the Supreme Court has the rights to interpret the Constitution, but interpreting a constitution is a different thing. And through interpretation, if you are going to add something in the constitution, that is absolutely a different thing. The constitution is, there is no provision, never ever in the constitution, that the vote of such people who have deviated from the directions of the party shall not be counted. Nothing in the constitution.
Okay, I'll come to that point.
What I'm saying, that when the court has decided that these votes shall not be counted, actually the court, in my humble opinion, actually the court has not interpreted the constitution. Actually the court has added something to the constitution.
This is a very important point.
Let me come back to you on this to make the constitution.
Later on
this
the show.
Let me
take the version from Mr. Khosa. Mr. Khosa, as you have already heard the two panelists over here in the studio talking about the constitution of the bench, isn't it the matter of solely the judicial discretion and the kind of trust and the confidence the entire nation and the institution pose in the Chief Justice of Pakistan being at the highest seat of justice?
Bismillahirrahmanirrahim. Allahumma salli ala Muhammad wa ala Muhammad. Well, I'll continue the conversation with, I'll not talk anything out of the Constitution and what we have learned from the judges and the Supreme Court of Pakistan through their judgments and what we have learned through the jurisprudence of justice. Let me read the very first line of the Supermoto case, in which 63B, not B, C was being implemented. Let me read first of all. I think so. We need to go through what exactly needs to be read out. Now I'm reading the judgment, starting by the Chief Justice Umar Ata Bandial Saab. The presidential reference moved by the PTI government to unseat the 20 members of the parliament. May I read and let's talk what they have said so. It is the Chief Justice Umar Ata Bandial has started with Surah verses of the Holy Quran 83 and 84. O my sustainer, endow me with the ability to judge between right and wrong, and make me with one with the righteous, and grant me the power to convey the truth onto who will come after me. Now I'll read out the judgment of the Honorable Chief Justice of Pakistan, page 54. I think we don't read the judgments and we just start commenting without reading the judgments. Let's read. I'll just read the page 54, para number 55. So these are the last 1, 2, 3, 4, 5, 6, 7 lines. A similar view was also taken by the court in respect of the Speaker's power of the National Assembly under Article 63(2) of the Constitution. Under the said provision, the Speaker may refer the question of a member's disqualification to the Election Commission of Pakistan, rejecting the contention that such a decision of the Speaker falls within the preview of internal proceedings of the National Assembly. The court in Muhammad Azhar Siddiqui versus Federation of Pakistan, PLD 2012, Supreme Court 774, and then afterwards the court agreed, yes, as per 63(2)(b, and read with the ending point, which says 63(2)(b says, it says that the parliamentary leader has to write the letter, but the court has dismembered them, relying upon the other part of the 63, which says if the party head is going to write down that they have bifurcated from the party policy, then the Supreme Court has said so in their own judgment. Yes, they
So,
are.
Mr. Khosa, what about para 9 of the same verdicts? That goes on to say, somewhere in the middle, the basic objects of Article 63A of the Constitution is to ensure that a member of the Parliament should not vote contrary to the direction issued by the parliamentary party. So now, when we talk about the remarks which were given by the Chief Justice himself in yesterday's hearing, he categorically said where the Deputy Speaker took the reference for his ruling to reject those 10 votes of PMLQ. Then the Chief Justice goes on to make the remark that it seems that the Deputy Speaker gave the ruling against the court's decision.
You see, that is what I'm trying to complete my conversation. That is where they have asked for the larger bench, and that what the public, the public and the people of Pakistan lack. That why there should be a larger bench. That is what I'm going to clarify right now. Let me complete in just few minutes. In this judgment, the
Please
Chief
go
Justice
ahead.
said so that they have they are defined from the party head directions, and now where they have said so, it has to be the parliamentary leaders. So there are two letters now. Number one, first letter is, this is a new proposition of the Constitution, trauma, Constitution, shroudiness, that the Constitution says the parliamentary head has to write the letter, but for them to be dismembered, they said so the parliamentary head has to write the letter and to convey to the Election Commission of Pakistan and the Speaker. And on relying upon the same letter, they have dismembered 20 of the people. Now the question arises, can the Supreme Court of Pakistan 5-member bench can defines from the definition which they have already laid down, 63B proviso, what I have read, so the party head. Now, if the Supreme Court agrees, okay, their vote can be casted, then it will be a great, big question mark onto the Supreme Court of Pakistan, then how those 20 members were de-seated and the expenses the Election Commission and the people of Pakistan had suffered from them after re-election, then who is going to be questioned? So that is why, if you see, There is no word. Supreme Court has introduced, and with very heavy heart, I have the right to criticize. Supreme Court has introduced a new word which does not exist in the constitution, that Hamza Shehbaz Sharif is a trustee chief minister. For God's sake, there are two things: caretaker chief minister or a permanent chief minister. Whether you set aside the notification of the speaker, Dost Muhammad Mazari, if you have not done that, then there is no word trustee chief minister. This will open a Pandora box to the political dialogue.
Right. That's
Number
another
one.
point. Right. Let me go back to Mr. Jalaluddin. Now, considering if the Supreme Court doesn't entertain and accept the request made by the ruling coalition of forming a full court into this petition, so what legal or constitutional remedies do you think would the ruling coalition have?
The ruling coalition will think over it. I think that Maulana Fazlur Rahman is addressing a press conference, just though he will be busy. But tomorrow when the hearing is on, so our legal team, they will appear and they will then be instructed by their clients. And this will be decided if the Supreme Court, if the present bench, the Chief Justice denies the request, then the opposition will definitely.
So what does the law say about it?
The law is very much clear that no one can sit on his own judgment. So this Supreme Court, this Atabandiales, my learned brother, has referred to certain judgments. Just 1 month before, the 20 votes of PTI, they were just de-seated on the very pretext that Imran Khan wrote a letter that don't cast vote, you will cast your vote in favor of Parvez Elahi. So they didn't consent, they were de-seated. So no, the question of, as my learned brother also referred to Article 63A, the Supreme Court judgment has not interpreted Article 63A, but they have rewritten this article. They have introduced certain things which are alien to the Constitution. The Constitution is very much clear, the 63A, that whoever cast vote against the directions of his party, then the complete process has been given in this article, that the party leader will then give him a show cause notice, and thereafter will address a reference to the speaker, and the speaker will forward it to the chief election commissioner. So I think that at that time also the Supreme Court Bar Association, the Bar Council, the political leadership objected to this judgment. But the judgment should be in rem, not only for one party, it should be interpreted in other way, and for another party it should be interpreted in another way.
But Chief Justice himself has to say something about it, Mr. Jalaluddin, and he said during yesterday's proceedings that we would not reconsider the verdict announced on May the 17th, as it has not been challenged here yet. So if there were certain objections, if you say that the Supreme Court has rewritten the Article 63, so there should have been a challenge in this.
The Supreme Court Bar Association has filed a review against that judgment, and our demand is that the Yusuf Raza Gilani appeal against the election of Chairman Senate, the Supreme Court Bar Association review petition, and all these, as these are related to one and the same issue, the question in controversy is the same. So all these be clubbed and should be heard by a full court of the Supreme Court, because the very important issue for the future of our constitutional history and democracy is at stake.
Right. Now we are joined by another guest, Barrister Muhammad Ali Saif. Barrister Saif, thank you very much for your time at Perspective. So we are talking about the demand of the ruling coalition regarding the formation of a full bench into hearing of this petition that challenges the ruling by the Deputy Speaker on Punjab Chief Minister's election. What's your take on this? And if the Supreme Court doesn't entertain this request, what would be the legal remedies to the ruling coalition according to the law?
I believe that the ruling coalition is actually using this argument as a ploy, as a tactic to avoid Supreme Court or to delay the Supreme Court's decision on this particular issue, which is the acceptability of ruling or the legality of the Deputy Speaker's ruling in Punjab Assembly. I personally do not buy the argument that the full court hearing is important for this particular deliberation because although there is no doubt in the fact that there are similar there are petitions pertaining to constitutional questions relating to Article 63's interpretation are pending before the court in different cases, but still this matter stands alone on its own footing, and it is just merely a question of not even the interpretation of Constitution, but just the exposition and explanation of the order by the Supreme Court itself in the same case wherein the Supreme Court had directed that a fresh election be held for the Chief Minister's slot. So why would somebody argue now that the same case which was heard by this bench, three-member bench, should now be heard by a full court? So therefore, I believe that it is just a political tactic, a political gimmick, and in a way, a ploy to pressurize the Supreme Court in, to render a judgment which is basically according to their choice and win.
Okay, so if the Supreme Court accepts this request by the ruling coalition, so is it okay with the leadership of the Pakistan Tehreek-e-Insaf and PMLQ alliance?
Well, I believe that the Supreme Court should not. If you take my opinion on this issue, I would suggest that the Supreme Court should not take this request simply on the ground that it is not a new case. It is not a new question of law that has appeared in a case or in this particular proceedings that happened in the Provincial Assembly of Punjab. It is a mere continuation of the same case. And the only reason that the court has now taken cognizance of this case and has taken notice and is hearing it and has already had a hearing on Friday is because the same order, the order of the Supreme Court in the same case has not been followed in letter and spirit by the Deputy Speaker. It is the Deputy Speaker's order which is before the Supreme Court, and the Supreme Court simply has to give an order on the explanation of its own judgment. Nothing to do with a question of law or anything, and I believe that
so, Barrister Saif, the leaders of the ruling coalition are of the view, as Mr. Jalaluddin was also saying, that Supreme Court happens to interpret the Constitution or the Articles of Faith, but rather it has rewritten the Article 63 altogether. A similar sort of a statement coming from PMLN Vice President Maryam Nawaz as well. A new interpretation is being made of the decision on Article 63A to benefit PTI chairman.
I personally think that, as I've already stated, what the ruling coalition is doing is basically trying to pressurize the Supreme Court and in a way trying to discredit the honorable judges in the bench and just trying to seek a decision or to get a decision or a judgment in their own favor. It's nothing more than that. Why would Maryam Nawaz suddenly realize that there is a wrong interpretation of the constitutional provisions? I mean, who is she to say that? She doesn't have any legal background. She's not a lawyer. She was never a party to this case. It is a political statement, and I'm repeatedly saying it's just a ploy. It's just a tactic. It's just a diversionary tactic to ridicule the Supreme Court, to undermine its credibility, and to take political advantage of the situation, and nothing more than that.
Right. Barrister Saif, please stay with us. So, Mr. Asim Mahmood, when we talk about the statement coming from PMLN Vice President, she dubs it as an arbitrary interpretation. As Mr. Jalaluddin is also, but on the other hand, you have heard Mr. Saif saying that it's just to malign the judiciary.
I think political interpretations might be different. They have their own point of view, but as a student of politics and a student of law, what I think this was not merely interpretation of the Constitution. The court has actually rewritten the Constitution, because in the Constitution it has never been mentioned that votes will not be counted. Votes were counted, and as a penalty they will be deseated. This is the jurisprudence of the Constitution. But when you say that votes shall not be counted, I think here the Constitution is amended, and the court has no right to amend the Constitution, and the court has no right to let President Musharraf amend the Constitution for 3 years. We have a history. We cannot forget that. So with due respect, we should say that some rules and regulations must come forward, and the scope of discretion must be minimized, and that can be done through legislation within the parliament. Not only this case, in my humble opinion, every case concerning the interpretation of the Constitution must be heard by the full bench. As in America, their Supreme Court, Constitutional Court, the full court hears any such matter. But because our Supreme Court is also a final appellate court, we cannot say that each and every case must be heard by the full court. But at least those cases that deal with the interpretation of the Constitution must be heard by the full court.
So according to you, what could be the solution? Where do you see the equation heading?
Yes, that's a very crunch question, and that's catch-22 situation. I think Parliament should come forward. The issues of the politics should be dealt with within the Parliament. Parliament should come forward, and Parliament should determine, and Parliament should explain that what is the essence and spirit of the Constitution. The votes shall be counted, or votes shall not be counted.
So if the Parliament was so unanimous, there was no need of heading towards the Supreme Court for interpretation and clarification.
Any party can go there. Any party can go there. Supreme Court, after all, is the most noble and most respected forum to provide the justice. But Parliament is also has the same importance. So the Parliament, this is the Parliament that has created the Constitution. And Parliament even can amend that Constitution. Votes are not counted as per the decision of the Supreme Court, but Parliament can sit and Parliament say that this is not provided in the Constitution, and Constitution actually never meant this. The votes shall be counted, and as a consequence of that vote, those people, those members will be deseated. That is the jurisprudence of the Constitution that I understand.
Right. Mr. Khosai, are there any remedies at the hands of the ruling coalition if the Supreme Court doesn't entertain and accept this request, as per the law?
Absolutely in agreement with my brother. You see, this is very important, as the Constitution cannot be amended by the Supreme Court, which unfortunately Supreme Court has taken the cognizance in a Supermoto presidential reference, in which they have cancelled 20 members, deseated, which was the job of the Election Commission, not the Supreme Court of Pakistan. Number one. Number two, now how can Supreme Court can say in this case that these votes have to be counted? So for this purpose, larger bench needs to be there. If the larger bench is not going to be accepted, the legal remedy which you have asked, which there is a provision of the review by the Supreme Court of Pakistan, which the PDM is going to exhaust that remedy. You see, Supreme Court cannot rewrite the Constitution, and unfortunately in the Supermoto case of the presidential reference, the Supreme Court has accessed its jurisdiction. So now I think so that larger bench, if the larger bench can be made in 2010, Supreme Court page 61 in the case of Chief Justice Pakistan Iftikhar Muhammad Chaudhary versus President of Pakistan, and if the larger bench can be made in the case of Supermoto case of Qazi Faiz Isa versus President of Pakistan PLD 2022, Supreme Court page 119, where the larger interest of the judiciary was involved. Here the larger interest of the people of Pakistan is involved, of the parliament is involved. Then I think so, where there is the people's interest is being watched, then there should be a larger bench, and this judgment should be reviewed, and keeping in the constitutional norm 63A, B, and to be read in toto, a judgment should be delivered.
Right. Thank you very much for your time. Mr. Balagh Sher Khosai, advocate, Supreme Court and legal expert, joining us on Skype. We really appreciate that. And we were also joined by Mr. Mohammad Jalaluddin, advocate, advisor to JUIF in the studio, and Mr. Asif Mahmood, political analyst, also joining us in the studio. We were also joined by Barrister Muhammad Ali Saif. Thank you all of your time at Perspective. And tomorrow the Supreme Court is going to resume the hearing, and whatever the decision comes, the law and the constitution must be held and must be respected by all the parties. That is all from Perspective, and we'll see you in the next episode. Till then, take good care of yourself.